Mentioned hearing above, we hope that there is no merit in the appeal. The appellate is what we discussed.
Yes.
Item number 8, Lordship. Also, finally, this matter may take any other day, Lordship. Voluminous, so it should be a paper book also, Lordship. There is a,
Mr. Ayub Choudhury, Learned Counsel appearing for the appellants. Comma, with the consent of Mr. R. Kuchik, Learned Petition, State Common, has made a prayer for adjournment of the appeal. Also, as paid for, comma, appeal stands adjourned. The hearing of the appeal stands adjourned for a period for 1 minute. Is that
Lordship, for one.
appeal according? Only going to need to expedite us.
Deeply obliged.
So may I pray for listing of a May appeal minor for others minor? Any date this week minor?
Not this week.
Monday minor?
Court martial will give the date. According to this
August.
What's it, item number 9?
9.
Steps are difficult.
Okay. Miss M. Normal and Amicus for the appellant is pending. The prayer of Mr. R. Kosik and traditional public prosecutor for the response state, comma. As part of prayer, lays the case of Wilson into these minutes. Yes.
May it please, your Lordship. Lordship, we have received the paper book.
Huh.
There's a last order says that if it is not expeditiously heard, Lordship will consider the IA. Or it can fix the order next week for hearing,
Hearing.
madam. Small
Okay.
matter, madam, otherwise. Next week, either third or fifth, if it's convenient to your Lordship.
Right, Punina picks precious, comments. Mr. D.K. Borosaji, Learned. You are, Micas or?
No, madam.
Okay, Learned Counsel for the applicant. And Ms. R. Kosik, Learned. Additional public prosecutor for the response state, present, Mr. As sought for by Mr. Borosaji, Learned Counsel for the applicant released the case on Thursday, next Thursday,
Fifth, I guess.
5th of June.
Obliged.
Public library. I will get a vote from my right now.
May it
Yes.
please, your Lordship. My lord, my lord, criminal appeal number 50 and 78 were appearing from those persons, my lord, appellants. So, my lord, in criminal appeal number 50, one of the persons, namely Sonju Pal. He
Sonju?
sent Sonju Pal.
Huh.
He sent for sent to the additional session judge number 2 Guwahati for determination of his age at the time of occurrence.
Huh.
And report has come in.
Lordship may kindly favor that, the flag minute of article 1.
Appeal number? appeal Sanju Pal. Okay.
And secondly, my lord, appeal number 78,
Hmm.
two appellants, my lord.
Hmm.
78, Hare Krishna Pal, my lord.
Hmm.
He was also sent to the additional session judge number Guwahati
Hmm.
for analysis of his age at the time of occurrence.
Hmm.
And that report has been received. So far, we have been informed.
Okay. And what about the other appeals?
In other, in our case, my lord, other person.
Hmm. Hmm. Okay. What about the other appellants? Huh? Shiva?
Shivapal.
By which order? 94 to some? Now, in these four appeals, three, two, 5, 6, 7. Total seven appellants.
Yes.
Yes. Now, according to you, Shivapal declared juvenile. Where? From where? From where? We can get that information. Ninety-four.
That report is, I have sent
I know. This Shivapal. Euro or I 222. Sir, why don't you equip yourself with the necessary information? Hare Krishna Pal,
Yes, ma'am.
is he still in custody?
Yes, ma'am.
Still in custody?
He is not in custody, ma'am.
Okay.
He has already been released on bail.
Okay. Then Porimal Paul? Hmm? He is in custody? Sanju Paul?
Sanju Pal, my lord, released on bail earlier occasion.
Huh. Sanju Paul released on bail. Shiva Paul already order passed.
Hmm.
Porimal Paul, did he prefer any IA earlier? Did he, had he preferred any IA earlier? IA Porimal Paul was IA as in 94 law. 94 to law related to IA. 1 minute, 1 minute. Pratap Paul. Porimal Paul of names. Porimal Paul. So Ahmed,
My lord.
this Sanju Paul, Hare Krishna Paul,
Yes, ma'am.
they were behind the bar since for what long period?
No, earlier occasion, they were on jail, my lord. Thereafter, they got bail, ma'am.
Ah.
They were released on bail. ma'am.
But
Both Sanju Pal and Hare Krishna.
period of custody.
Yes, ma'am.
Period of custody.
Date of judgment, ma'am. Date
Ah.
of judgment of sessions case number.
Then when they were released on bail,
Released on bail.
can you
ma'am.
calculate? Because it has some consequence.
Hare Krishna Pal, my lord, so far copy shows on 26/7/2016, my lord.
Me? Pratap and another. Who is in criminal appeal number 94 of 2016? Huh? Huh. This, no, 1 minute. Shiva Paul, Pratap Paul, Porimal Paul. Now, whether Pratap Paul is still alive? Is he no alive or not? Huh? Because in 2022, you said that he is 81 years old. Right. Now today, He is about 84 years, 84 years. That is why I have asked the query. Because, hmm? Who represents Bipul Paul? Huh? Bipul is in Boil. 1 minute. Nirmal Paul?
Nirmal Pal is in jail, man. Since the date of judgment, original sessions case number. my lord. Now he completed,
Sanju Paul?
Sonju Pal outside the jail, my lord. He got bail, my lord.
Hare Krishna Paul?
Hare Krishna Pal also released on bail, my lord.
And Porimal Paul? So, Mr. Kaushik, out of 7 appellants, four are considered to be juvenile. And 3 are not juvenile. So their appeals are to be heard. Out of 4 juvenile, 3 are on bail. Mr. You file an I immediately on the basis of the report. And we hear the appeal on merit. Pratap Paul, Bipul Paul, Nirmal Paul.
Nirmal Pal.
Start.
Yes, my lord, here, my lordship,
Hmm?
that may be given, short date may be given. Or
So there it is come for hearing.
Lordship, in short, my lord, whatever we have, during the paper book, my lord.
Ultimately, it is 302.
My lord, there is no specific evidence against this accused person, Nirmal Pal.
Because we have to segregate Mr. Hassan for the purpose, because 3 are already major. To at least to allow Porimal Paul to go on bail. We'll decide about juvenility, on the matter of juvenility, how to do it. But on prima facie, he is juvenile. But otherwise, his involvement in the crime is to be considered. And even if the other juvenile are on bail, but still they have to go the reformation for a period of 3 years at least.
Yes,
That order has to be passed. Right. So you file an I in case of Porimal. We'll consider that on merit as on the basis of the report. And since Mr. Ahmed is not ready, are you ready? Are any of your client is in jail? Pratap Paul. So we have to hear his case on merit, right?
yes,
Then Bipul Paul, we have to hear his case on merit. Maybe he's on bail, but madam, we have to hear his case on merit. He's not juvenile. Then Nirmal Paul,
yes, ma'am.
his
He-
case
he
is to
should
be
have
heard on merits.
Yes.
Along with that, their juveniles are involved.
Yes, absolutely.
Then also they have to undergo something.
Yes, ma'am.
May not be jail sentence, but they have to go through some kind of, some measures are to be
Yes.
taken in their case. Maybe on their
Yes,
They are
yes.
on bail. So that is why, Mr. Hassan, to segregate, it is very difficult for us also, 7, because we are to hear all the appeals. Then only the final order of Shivapal already done. Shivapal already done. This Sanju Pal and Hare Krishna Paul, they are on bail. Hare Krishna Paul and Sanju Paul, they are on bail.
Then
Only Porimal Paul is there.
Porimal Pal and in our case Nirmal Pal,
Huh?
50.
Oh, no. I am talking about juvenile. Juvenile. Juvenile is Sanju Paul.
Yes.
He is on bail.
Then
Next is Hare Krishna Paul. Who represents Hare Krishna Paul?
I-
You.
Yes,
He is on bail.
then
And third one is Porimal Paul. He is not on bail. Huh? Otherwise, their involvement in the crime is to be considered. So you file an IA for Porimal Paul, then we'll allow him. Otherwise, his involvement is to be looked into also. Thereafter, appropriate that he is to be sent to the this juvenile justice 3 years if he is found guilty.
yes.
3 years in some home, this has to be ordered. We cannot. Maybe Shivapal has been done away with. But it should be I do some. You file, then we will pass an order similar to Shivapal. Right? If file an IA, we'll pass an order similar to the order passed in case of Shivapal. Right? Then we can hear the other appeals also. At least his case will be treated by the Juvenile Justice Board. Like Shivapal. Then we'll hear the cases of Pratap Paul, Vipul Paul, and Nirmal Paul.
Yes, for 3 persons. Here will be hearing for 3 persons. And others and to
You
the.
are not ready today.
I also applicant today.
You are also not ready.
Because Dr. is Jahan.
Then we'll simply adjourn. Mr. Hassan, you do your needful immediately. Mr. Ahmed may not be ready for next 1 year also. So this Porimal Paul case is to be separated. Right? You do it. I'll not reflect in the order. It is for you. But Mr. F.A. Hassan, 313, 313 is not up, 313. 313. IA 313. IA 313. Wait one second. So it is for us to look into the cases. Applicant, one of the applicant is Porimal Paul. You don't know. You don't know. You have not said so. We are hearing hearing you for last 25 minutes. What are the applications? What do you mean? Ah. Hmm. Okay, Mr. Hassan, we'll put it on Friday.
Friday.
We'll go through it,
Yes,
pass the order on this eye.
yes, only this I am, madam.
Ah,
And Friday, Monday, madam. My senior is out of store, he's in Calcutta, madam. It may be fixed on Monday.
your senior is not required. You come prepare.
Yes, madam.
Why you are experienced
Yes.
enough?
Yes, madam. Yes. I'll be back.
Yes, Mr. Kosik. Porimal Paul's application is there. We'll do it. His eye will be considered. Friday,
Right. Friday. madam.
you go through it.
Right.
All the provisions of juvenile justice.
Yes, sir.
I also don't know.
I'll be there. madam. Yes.
So this can be, one part of the issue can be solved. You will be ready Friday? Okay, Mr. F. A. Hassan. Heard Mr. F. A. Hassan, learned counsel for the appellants in two. Mr. Ed Ahmed. For the appellants,
I'll put on the bill. Yes.
3 and 4. And Miss N. Ahmed. You are amicus? Oh, Arbego. Learned counsel for the appellant in 5. The plural আছে appellants full. And Mr. R. R. Kosik. Learned the additional public prosecutor for the respondent number 1 for state of Assam. Who are the counsels for the respondent number 2? The learned counsel for the respondent number 2 is found absent today on call. Post. As the prayer of Mr. Hassan and counsel for the applicant in IA criminal 313 2021
21.
is the case on Friday for consideration of the IA criminal 313 2021.
Yes.
You read the order in 222.
Obliged, madam.
Ninety-four to you. 94 to you. Second to you, 94.
Just be it.
Cataract. Because yes. Law says after 30 years, ossification test carries no meaning. And these appellants, ossification test was carried out when they are 35, 40 years. That aspect you have to look into. There is one judgment, Binod Katara, 2022 Supreme Court.
If I'm not wrong, just because one person, gives 35 years.
35 years, 40 years, all of them. It carries no meaning. So whether on that basis,
Apparently here there was no document otherwise.
no document.
But a report.
And if the law says or science says, after 35 years, ossification test carries no meaning and it is not the right test to determine age, then what will happen?
The initial test, they could not determine. Subsequently, the skull X-ray was done. That's what I report.
So find out this Bindu Katara what it says. Thereafter, one for Pavan Kumar, it also says, after age of 30, ossification test does not carry any meaning or it is not to be used for determination of age. All these appellants, when their ossification tests were carried out, they were 35 years to 40 years. And they don't have any document,
Not a single thing.
not a single piece of document. So what is to be done in that case? If they may be allowed to release on bail just for the sake of it, the other one, which is still in jail, who is still in jail,
84 days.
or whatever, on the basis of report. But this report is to be considered on merit. All the 7, all the 6, one has been done away with. But other 6, maybe we may discard this report also.
It
That is also open.
cannot be accepted.
Face value cannot be accepted, perhaps. So examine the issue and law and come on Friday, so that we can make more huh, study.
But if possible, can I? Okay, okay, report possible.
Report. Oh, anything. Um, a registry. A registry to, as per the request of Mr. Kaushik Lanet, additional public prosecutor, comma, the registry to furnish a copy of the inquiry report. Last page কোনে করেছিল? Dated
Dated 14/11/20.
16/11/2023 of the additional district and session judge number 2, Kamrup Metro, Guwahati. Within 3 days from today.
6 and 7.
Ready, but the file is
It's a date reference case.
different. It takes time.
Okay, we'll post it after 1 or 2 weeks because we don't know the composition also. Maybe it may change. Mr.
Yes,
You are ready?
That's Lordship.
You are ready?
Yes, perhaps Lordship.
Huh?
Perhaps we have,
If they will start and I can,
oh, but today we have some sort of difficulty, my lord.
You are Mr.
Das Lordship. On
J.
behalf of
Das.
Mr. A.K. Williams, Lordship.
On behalf of
A.K. Williams.
appellant.
Yes, Lordship.
Okay.
In item number 6, you have to respond.
Mr. J. Das, Granite Council for the appellant in 7 and for the respondent in 6 and Miss A. Begum, Learned additional public prosecutor for the appellant in 6 and additional public prosecutor for the state are present. As sought for by the learned council for the parties, release the cases after a week on the leave to release.
their issues is also on division. Because according to them, the accused lordship, he didn't went to school and he have no such certificate. But lordship, he went to, school. There is, so
Right.
On name of Mr. Jade Kamar, Learned Senior Counsel, Learned Senior Counsel, amicus, be reflected in the cause list. In 6 and 7. But he's already there. No, his name is already there. Okay, Mr. Okay, Mr. P. D. Chaudhary, Learned Counsel on behalf of Mr. Jade Kamar, Learned amicus curiae, is present. Odd. Yes. Yes.
Lordship, FIR is a page 4.
Hmm.
It's a conviction under 302, Lordship.
Hmm.
Page 5 is the FIR, Lordship.
Okay.
Relevant person.
Hmm.
The informant is a permanent resident of the above mentioned locality
Around 10 years ago, my daughter Lota Rava was married off to Sabnam Rava. Upon getting a house constructed at a place at some distance from my house, he along with his family had been residing there for some 3 years. Around 5 p.m. yesterday, that is on 9/11/13, the said accused, my son-in-law, killed his wife, my daughter, by hacking her with a dao inside his house. His minor daughter, Sri Purnima Rabha, aged about 4, who was present at home at that time, came to my house and told us in tears that her father had beaten her mother. Then I, along with my family, went there, saw cuts on the neck and cheek of my daughter Lota Rava, and found her dead. The said accused escaped from his house after killing my daughter. I therefore pray to you to take necessary action against the accused upon carrying out an investigation into the matter of lies. So lots of one aspect also I'll just point out so that like it will come later on. Here lots of they say that the statement is that his minor daughter Purnima Rava, who was present at home at that time, came to my house and told us in tears that her father had beaten her mother. So the daughter went to the house of the grandfather and intimated the grandfather, crying that her mother was killed.
4 years, if she is
4
really
years.
4 years, what is killing, what is not killing?
No, I'm not into that. Like visiting the house, visiting the house. So went to the house of the grandfather. So now Lordship will finally come to the page number 9 directly. The depositions. So Bikram Kosari is the father of the victim and he is the informant. Page number 9. Name is Bikram Kosari, resided Hatidoba, Borduar Bagan, Palakpani. I am the informant of the case. I lodged the Azahar against accused Satram Rava. The incident took place less than a year ago, around 5:30 p.m. Accused is my son-in-law. One day, his daughter, that is my granddaughter, Purnima Rava, came to my house weeping, and she told me that her mother, that is my daughter Lota Rava, was beaten by her husband, that is the accused. After getting the information, I, along with my family members and Roma Kosari, proceeded to the place of occurrence, which is situated a little distance from our house. On reaching there, I found my daughter lying inside the house with cut injuries of her left ear, cheek, and neck of the left side. Blood was coming out from the injuries. A dog was lying nearby the dead body of my daughter with blood stains. Accused, that is my son-in-law, was not found there. He absconded. Thereafter, on following day, I filed an Azahar at the police station as on that date of incident, it was getting dark at the time of our arrival at the place of occurrence. Exhibit 1 is my Azahar. Exhibit 1.1 is my signature. It was written by a person on my instruction and read over to me before I put my signature. After filing the Azahar, police arrived at the place of occurrence and took the dead body to GMCH, Guwahati. Police on arrival at the place of occurrence prepared inquest after examining the dead body and took my signature. Exhibit 2 is the inquest report. Exhibit 2.1 is my signature. On that day also, the accused was absent. He fled away on the previous night after the incident. That a cross-examination part also. The incident took place on 9/11/2013. At the time of the incident, I was at my house. From my house, the distance of my son-in-law's house, that is, the house of the accused, will be about 100 meters. I have not witnessed the incident of assault by myself. My daughter and accused got married about 10-11 years ago. I do not know anything about any quarrel took place between my deceased daughter and the accused. So he was not aware of any quarrel or any kind of conflict between these two persons. It is not a fact that there was quarrel between my deceased daughter and the accused. Then Lordship will find the accused quite often used to beat my daughter. So the previous statement is that like, he is not aware of any quarrel. Then now he is saying accused often, accused quite often used to beat my daughter. It is not a fact that accused did not beat my daughter. It is not a fact that accused did not commit any offense. It is not a fact on the date of occurrence accused was out of house since morning, that is prior to the occurrence. It is not a fact that I had no good relationship with the accused from earlier. My daughter was lying dead in the house situated on south, facing the head towards the east. Dead body was lying headlong with the face towards the eastern side. Dow was lying on the right side of the dead body. It is not a fact that the said Dow does not belong to the accused. Police recorded my statement in the police station. Azahar was not written by any police personnel, but by a person known to me at my instruction. It is not a fact that I falsely implicated the accused with the offense and deposed against him falsely. Then PW2 will also be page 12. His name is Kirot Kosari, and his residence is somewhere else. It's called, it's named Rangamati. I reside at Rangamati. I know the complaint Vikram Kosari, accused is also known to me. The incident took place on 9/11/2013 around 5:30 in the evening. On the same day, around 7 p.m., I came to know from one Manuranjan that accused hacked his wife to death. Manuranjan informed me about the incident over phone. After getting the incident, I went to the house of Satram, accused situated at Hatidawa. After my arrival, police reached the place and found the dead body lying inside the house of the accused. I noticed the cut injuries on neck, cheek, and other parts of the body with bleeding. I also noticed a dowel lying near the dead body. Police seized the dowel and prepared the scissor list and took my signature there. Exhibit 3 is the scissor list, wherein Exhibit 3(1) is my signature. Material Exhibit 1 is the seized dowel. I have today seen in the court. Police examined me on that very day and recorded my statement. Police held inquest over the dead body after examining the same and took my signature on the inquest. Exhibit 2 is the inquest and Exhibit 2 is my signature. The incident was witnessed by the daughter of the accused and deceased Lota named Punima. It was told to me that she had witnessed the incident. So it was told to me that she had witnessed the incident. Cross-examination. The incident was over when I arrived at the house of the accused. At the time of the incident, I was at my residence. About 1 hour after the incident, I came to know about it. The dead body was lying with head towards south side. Face was lying towards the floor. I cannot recollect on which side of the body of the deceased injuries marks were seen. When police took my signature on the scissor list, it was written. Police wrote the scissor list on the spot, and I also put my signature on the spot itself, not in the police station. Police brought the seized down to the police station after preparing the scissor book. PW3, Dr. Manoj Kumar Bashir, page 15. On 10/11/2013, I was working as PG trainee at GMCH. On that day, I had done postmortem on the body of daughter Rava, 28 years female, daughter of Bikram Kosari, and wife of Satram Rava, alias Patik, village Hudava, PS Polasbari, escorted by UBC 374, Jagat Deka and Vikram Deka in connection with Polasbari PS GD number 285 dated 9/11/2014. External appearance, the female dead body of average build of Swati complexion, this would be complexion found, wearing red colored blouse and yellow sari and white color woolen clothes. Eyes and mouths closed, body cold on touch, rigor mortis fully developed. Injuries: chop wound of size 12 cm, 3 cm, bone deep present left side face extending from angle of mouth to tragus of left ear. Chop wound of size 6 cm, 3 cm, bone deep present 1 cm below injury number 1. Chop wound size 16 cm, 3 cm, vertebrae present 2 cm lateral to injury number 2. Chop wound 10 cm, size 10 cm, 5 cm, vertebrae deep present back of neck. All other organs were pale. Opinion: the death was due to hemorrhagic shock as a result of injuries sustained as described. All injuries were antemortem and caused by moderately heavy sharp-cutting weapon and homicidal in nature. Approx time since death 12 to 14 hours. Exhibit 4 is the PM report. Exhibit 4.1 is my signature. And Exhibit 4.2 is the signature of Dr. Nayan Kumar Das, demonstrator, Department of Traffic, GMCH, which I know. Exhibit 4.3 is the signature of Dr. A.Z. Patwari, Associate Professor, Department of FM, GMCH. Exhibit 2 is the inquest report, and Exhibit 2.3 is my signature. Exhibit 2.4 is the signature of Dr. Nayan Kumar Das, Demonstrator of Forensic Medicine, GMCH. Exhibit 5 is the command certificate, and Exhibit 5.1 is my signature. And Exhibit 5.2 is the signature of Dr. Nayan Das, Demonstrator, FM, GMCH, which I know. Exhibit 6 is the forwarding letter, and Exhibit 6.1 is my signature, and Exhibit 6.2 is the signature of Dr. Nayan Kumar Das, Demonstrator, FM, GMCH. Exhibit 7 is the dead body challan. Exhibit 7.1 is my signature, and Exhibit 7.2 is the signature of Dr. Nayan Kumar Das, Demonstrator, FM, GMCH. Cross-examination part: the dead body was identified by guardian and police. I personally do not recognize the dead body. The injuries found cannot be caused by other reasons than that described. Then PW4 Lordship, this page 18, Chandrakanta Kalita. This is investigation officer. On 10/11/2013, I was working as SI of police in Kamalpur PS. On that day, one Vikram Kasari lost an Azahar. Accordingly, it was registered at Polasbari PS case number 376 of 2013 under section 302 IPC. The said Azahar is Exhibit 1, and Exhibit 1.1 is the signature of the 10 OC, Polasbari Police Station. Exhibit 8 is the printed form of the FIR, and Exhibit 8.1 is the signature of the then OC, Polasbari Police Station, which I know. After registration of the case, I was endorsed to investigate the case. On 9/11/2013, one Deposit Rabha, who was ARSU president, had informed the police station by telephone. Whereupon GD entry number 285 dated 9/11/2013 was made. Exhibit 9 is the extract copy of the said GD entry, and Exhibit 9.1 is the signature of the Dan OC Polasbari PS, which I know. On the basis of the said GD entry, I went to the place of occurrence and drew a sketch map of the place of occurrence, which is Exhibit 10, and Exhibit 10.1 is my signature there. I inspected the place of occurrence and examined 3 witnesses. The dead body was brought to the police station, and inquest 1 was done over the dead body. Exhibit 2 is the inquest report. The inquest was done by Executive Magistrate Polasbari Revenue Circle. On the same day, the dead body was sent to the post-mortem examination. Exhibit 6 of the police forwarding for the said post-mortem examination, and Exhibit 6(3) is my signature thereon. The name of the deceased, Lata Rava. Exhibit 7 is the dead body challan. Exhibit 7(3) is my signature thereon. Later on, I collected the post-mortem report, which is Exhibit 4. On 9/11/2013, the alleged offending weapon was found at the place of occurrence, and it was seized before 3 witnesses. While Exhibit 3, Exhibit 3(2) is my signature on the seizure list. I also recorded the statements of the seizure witnesses under Section 161 CRPC on 10/11/2013. Further, on 10/11/2013, after lodging of the formal Ezahar by the informant and other witnesses were examined in the police station itself. After completion of the investigation, upon finding sufficient incriminating materials against the accused, I submitted charge sheet against him under Section 302 IPC. Exhibit 11 is the said charge sheet, and Exhibit 11(1) is my signature thereon. Cross reserve. Then the cross-examination part is at page 20. I recorded the statements of the witnesses at the police station itself. None of the witnesses examined by me had stated that they had seen the incident themselves with their own eyes. So none of the witnesses examined by me had stated that they had seen the incident by themselves with their own eyes. I examined and recorded the statements of the seizure witnesses on 10/11/2013, and the statements were also recorded in the police station itself. After completion of investigation, I submitted charge sheet against the accused on 23/12/2013. It is not a fact that all the formalities of the case were done in the police station itself, and it is not a fact that I have not conducted investigation into the case properly. It is also not a fact that I have falsely submitted a charge sheet against the accused. The only thing, Lordship, is that the child was not examined by the police. Her statement was not taken. Though child was supposed to be the only witness in this case. Page 21, Lordship, will find PW5. Sri Sudhanath Boro. He also is a resident of Hatidoba. It's the same village. I know the informant and the accused person of this case. The incident had taken place on 9/11/2013 at about 5:30 p.m. in the house of the accused. About 10 years prior to the incident, Lata Rava, the daughter of the informant, was married by the accused. About 3 years prior to the incident, the informant had constructed a house in his basti and allowed his daughter and the accused to stay there. Suddenly on 9/11/2014, accused assaulted his wife with a dog and absconded. Hearing the hue and cry in the house of the accused, my wife told me to find out, and accordingly, I went to the house of the accused immediately, and there I saw that the dead body of the deceased was lying in the house. At the place of occurrence, at that time, I also saw the informant and his wife. There, Purnima, the daughter of the accused, aged 4 years at that time, was crying, and I came to know that the said girl had gone crying to the house of the informant, informed the informant about the incident, that the accused had assaulted her mother with a dog and killed her. So here also same thing, the daughter has gone there. That's what he had been intimated. The grandfather's house. The police had come to the place of occurrence and conducted investigation. One magistrate had also come to the place of occurrence, and he conducted inquest over the dead body. Inquest report was written in English, and it was explained to me. Exhibit 2 is the inquest report, and Exhibit 2(5) is my signature thereon. I had seen the dead body, and I saw injuries on the dead body, on the neck, left side of the cheek, and left side of the ear. I saw bleeding from the injuries. I did not see the accused at the place of occurrence, even after the police had reached there. Police had seized one dog from the place of occurrence, and there were some blood stains on that dog. I would recognize that dog if I see it. Exhibit 3 is the seizure list pertaining to the seizure of the dog by the police, and Exhibit 3-4 is my signature thereon. Later, police sent the dead body for postmortem examination. Subsequently, the police again came to the place of occurrence. On the next day of the incident, the police had examined me with regard to the incident and recorded my statement. Cross-examination part of it. The distance between my house and place of occurrence would be about 200 to 300 meters. On 9/11/2013, at the time of the incident, I was in my house in the kitchen. The informant is not my relative. I have not seen myself the actual incident of assault made by the accused upon the victim. I have not seen myself Purnima, the daughter of the accused, giving information about the incident to the informant. I have not seen myself by myself Purnima, the daughter of the accused, giving information about the incident to the informant. I have not asked anything to the girl Purnima. That Lordship may kindly note it. That I have not seen myself, Purnima, the daughter of the accused, giving information about the incident to the informant, and I have not asked anything to the girl Purnima. When I had first reached the place of occurrence, I found about 10-20 persons. Some of these persons were Ramakanta Kosari, Manoranjan Kosari, and Gaunbura Kyot Kosari, Deposit, the president of Rubber Students Union, and his colleagues, etc. I have heard about some quarrel between the accused and the deceased in their conjugal life, but I have personally not seen any such quarrel. I do not know as to why there was such quarrel between the two. I put my signature under Exhibit 3 seizure list at the place of occurrence itself. I put my signature on Exhibit 3 as a witness upon instruction of the police. It is not a fact that I do not know anything about the incident. It is not a fact that I have falsely deposed in court today. Page 23, Lordship, PW 6. His name is Bhanokanta Kosari. He is also a villager of the same village. I know the informant and the accused person of this case. The incident had taken place on 9/11/2013 in the house of the accused. In the house of the accused. In the incident, the accused had cut his wife Lata with a dowel and absconded. On the day of the incident, while I was going on my way, in front of the house of the accused, I saw Purnima, the minor daughter of the accused, crying and telling informant that her father had cut her mother. So this is slightly a different version also. Slightly a different version, which says that on that day of the incident, while I was going on my way in front of the house of the accused, I saw Purnima, the minor daughter of the accused, crying and telling the informant that her father had cut her mother. So the place of information, basically the first information, the place of information as per the FIR and as per the deposition of PW1 is like the grandfather's place. And here this PW is saying that he saw Purnima, the minor daughter of the accused, crying and telling the informant is this father-in-law of the accused, informant that her father had cut her mother. I also heard the crying of the wife of the informant, and thereupon I went to the house of the accused, and there I saw the dead body of the deceased with cut injuries on neck, ear, and cheek. There was bleeding from the injuries. At that time, I did not see the accused there, and he had run away. At about 7 p.m., the police came the place of occurrence. The police again came to the place of occurrence in 2 days. The police examined me on all 3 days and recorded my statement. Later, the accused surrendered before the police. Later, the accused surrendered before the police station. Accused did not tell us anything, but confessed his guilt before the police. I saw the accused making his confession before the police. So this is also a statement also that he has confessed.
That has no value.
No value. The distance between my house and the place of occurrence would be about 200 meters. At the time of the incident, I was walking by the roadside. I have not seen by myself the actual incident of assault. I did not ask anything to the minor daughter of the accused. He also didn't ask the minor daughter about anything. Actually, in fact, in the whole case, nobody has asked the minor daughter. Only the informant and his wife were saying that minor daughter went there and said that her father had killed her mother. I called the informant uncle. It is not a fact that the accused did not commit the incident. It is not a fact that I have deposed falsely in the court today. Then period is 7 year or so,
Yes.
page 25, Jiten Boro. He is also a poor villager.
Hmm.
I know the informant of this case, and he is my Jiten Boro is in fact Lordship, that son of the informant and brother-in-law of the accused. I know the informant of this case. He is my father. I also know the accused person of the case. He is my brother-in-law. The incident had taken place on 9/11/2013 at about 5:30 p.m. 5 p.m. in the house of the accused. On the day of the incident, Purnima, the daughter of the accused, came crying to our house and told that her mother, Lota, had been cut by the accused. At present, Purnima stays in her house. Thereupon, I, along with my father and other poor villagers, went to the place of occurrence immediately. At the place of occurrence, I found my sister, Lota Rava, in dead condition. On the dead body of the accused, I saw cut injuries on the neck, left side of the ear, left side of the cheek. At the place of occurrence, one blood-stained dog was lying on the ground. The police reached the place of occurrence at about 7:30 p.m. The police inspected the place of occurrence. The police seized the offending dog at the place of occurrence in our presence and made the seizure list, which is Exhibit 3, and Exhibit 3.5 is my signature thereon as a witness. The seizure list was read over and explained to me, whereupon I put my signature thereon. The police took the dead body for postmortem examination. Later, the police again came to the place of occurrence. Police had examined me and recorded my state cross-examination part. At the time of the incident, I was in my home. Between the house of the accused and one house, there is only one household. I have not seen actual incident of assault by the accused. The deceased Lota Rava is my sister. I reached the place of occurrence on the day of the incident about 15 minutes after the incident. It is not a fact that my sister was killed by some other person. It is not a fact that I have given evidence against the accused today in court as because the deceased is my sister. It is not a fact that I have falsely deposed in the court today. In PW 8, Lordship, Manoranjan Kosari at page 27. I know the informant and the accused person of this case, and both are my co-villagers. The incident had taken place on 9/11/2013 at about 5:50 p.m. in the house of the accused. At that time, I was coming from the market and upon hearing when cry in the house of the accused, I went there. At a place of occurrence, I saw Lota Rava lying dead, cut injuries on her neck, left side of cheek and left ear. There was bleeding from injuries. I did not see the accused in the place of occurrence. The accused had absconded after cutting his wife. At the place of occurrence, I had met about 9-10 persons, including the informant and his family, Ramakanta Kosari, Nath Kosari, Jitan Boro, etc. The police came to the place of occurrence. After I had reached there, police had taken the dead body for post-mortem examination. I accompanied the police. The police examined me and recorded my statement. I came to know from the informant that informant was informed by a 4-year-old daughter of the accused that the accused had cut his wife. So here also the information was got from him only, the informant only. I have cross-examination part. I have not seen the actual incident of assault by myself. Then Lordship, I have not asked anything to Punima, the daughter of the accused. He also didn't ask anything to the child. Punima also did not tell me anything regarding the incident. The informant is not my relative. It is not a fact that the disease was not cut by the accused. It is not a fact that the disease was cut by some other person. I have not seen by myself the accused running away after the incident. It is not a fact that I do not know anything about the incident. It is not a fact that I have falsely reposed in the court today. So Lordship, all these witnesses, they haven't asked the little child what had happened. Then Lordship, that the vital witness, star witness, that child at page 29, PW9, Miss Punima Rama, by the time she became 7 years old, primary questions that 3 questions have been put. What is the name of your school? Hatiduba Primary School. This is very crucial, Lordship. I mean, like what questions have been asked, whether the child was in the capacity of giving the position, why it can be really taken into account in the right sense. Who all are there in your house? My grandparents, Rukmini Bai, Nisa Bai, Mama. Should you speak the truth today or false? Then her answer was, one should speak the truth. Then after the aforesaid preliminary questioning, I am satisfied that child witness can be examined. So these were the questions put to the child to basically examine whether she understands the things or not, whether she understood the things.
It is the judge
It is a judge.
who is experienced enough that whether
So
the child
he
has the necessary understanding or not.
correct. He's supposedly experienced, and he has asked this.
Trained judicial mind.
Yeah, he asked these 3 questions. So he was satisfied. It seems he was satisfied with the question. And lots of the preposition part, the incident had taken place in our house. At the time of the incident, I was in the house along with my father and mother. On the day of the incident in the evening, my father cut my mother on neck with a dao, and thereafter threw away the dao and ran away. My mother thereafter fell down and she died. I got very scared and I started crying. Thereafter, I went to the house of the grandfather and told my grandfather about the incident. I have seen my father cutting my mother. I had told before my grandfather about seeing my father cutting my mom. My grandparents, my uncle and others came to the place of occurrence and saw my mother lying dead. The dao was lying at the place of occurrence. After the incident, on the same day, the police came to the place of occurrence. The police came to the place of occurrence. The police took away the dao and also dead body of my mother. She remembered everything. She remembered everything.
For your benefit,
Lordship?
I have gone through the case diary.
Lordship.
IO
Yes, sir.
on the date because there is a GD entry, right?
Right.
Immediately after that, he visited the place of occurrence.
Yes.
Statements are recorded therein on the day of the commission itself. And IO Ute Toka পৰকীয়াজনে হত্যাকাণ্ড সংঘটিত কৰাৰ সময়ত তেওঁৰ 5-6 বছৰীয়া ছোৱালী পূৰ্ণিমা ৰাভাই দেখা পাইছিল। ছোৱালীজনী নাবালক কাৰণে তাইৰ জবানবন্দী গ্ৰহণযোগ্য নহয় যদিও পূৰ্ণিমা ৰাভাই গাঁৱৰ আন বহুতো লোকৰ সন্মুখত তাইৰ পিতৃ সদনাম ৰাভা তাইৰ মাতৃ লতা ৰাভাক গাৰে ঘপিয়াই হত্যা কৰাটো কয়। Why he did not record the statement under section 161 of the child. Then, during the course of the trial, on 24/5/2016, Sessions Court judge order. One petition was moved after examination of PW 5, 6, 7, and 8 by the learned additional public prosecutor, praying for calling of Srimati Purnima Rava, the minor daughter of the deceased, as prosecution evidence. The defense has no objection to the said petition. So these are the underlying facts. Right? Because since you have said that her 161 is not there,
No,
so
no,
these
he's
are these are the background facts. It is in the in black and white.
No, no,
And this
I'm grateful
note,
to your lordship.
this toka is on the date of the incident itself.
You're correct, lordship,
Long
but the only thing is that like, I don't know why this investigating officer, while deposing before the session judge, did not tell about these things.
Okay, you tell me.
He didn't tell anything about this.
You tell me why গ্রহণযোগ্য নহয়.
No, he said.
Why he has recorded
Lordship may kindly see what he said.
that child also said police did not record my state.
He didn't mention about this toka and everything.
No,
But
no,
he-
he is not required.
Yes, it's not required. Maybe it's
Not
not required, but he
Not
didn't
required.
mention
Come
about
to the statement of the child.
Yes, I'll just come. I'll just.
She
read
was
out one
candid
thing.
enough to say that police did not record my statement. Page 30, just before cross two line.
Yes, yes.
Police did not ask me anything. And I was crying. Maybe some human could be a human thing.
No, was it like, I mean, like, lordship, here, let's say, only witness is the child. Only his witness is the child. Any human, anybody who visits the place of occurrence, if I think of myself, if I go to the place of occurrence, I will ask the child, Ihul, what has happened? That's a very normal human
He
tendency,
heard it.
very normal
he-
human tendencies.
He heard it. He said he heard it. Saying to
But he didn't feel like
tell
asking.
me that why he must have recorded the statement of 4-year child.
No, lordship.
Please tell me what is the
No,
law that he
because-
should have.
No, because thing is that,
Tell me on law.
no, because the thing is that it is a natural and very general kind of human tendency that if somebody is there present and somebody can speak, at least speak and understand things, a 4-year child can understand and speak. So he could have at least asked the little child what has happened, but he didn't do that. At least asking parts he should have done. In fact, nobody other than the relatives, I mean, like father, the brother-in-law, nobody has asked. Any of the witnesses, none of the witnesses had in fact asked the little child what had happened. The information only came from the father-in-law and the brother-in-law. That's a little bit surprising, and it creates a doubt.
Yes.
Lordship is referring to some,
No, I'm not afraid. Yes.
the second paragraph also, page 30. Thereafter, I went crying to the house of the grandfather and told my grandfather about the incident. I had seen my father cutting my mother. I had told before my grandfather about my seeing my father cutting my mother. My grandparents, my uncle, and others came to the place of occurrence and saw my mother lying dead. The dog was lying at the place of occurrence. After the incident on the same day, police came to the place of occurrence. The police came to the police came to the place of occurrence. The police took away the dog and also the dead body of my mother. The police did not ask me anything, and I was crying. From then onwards, I am staying in the house of my grandfather, and even now I am staying with my grandfather. The cross-examination party, Lordship. The incident had taken place in my house. At that time of the incident, I was inside the house near my parents. Prior to the incident, on the day of occurrence, there was no quarrel between my father and mother.
Yes.
So, Lordship, that is also very important. Lordship, may kindly note that there was no quarrel. Nothing happened. Prior to the incident on the day of occurrence, there was no quarrel between my father and mother. Prior to the incident on that day of occurrence, no other persons came to our house. I have not deposed today in the court on the basis of any tutoring. I know the incident myself. It is not a fact that at the time of incident, I was not present inside our house. So it's very clear and specific, not like a typical child.
A child has become professor in Harvard or something. In the
Like,
age of 12 years.
While I was going through, like, it looks like a very professional kind of a witness, the ways he was deposing. Anyways, Lordship, that
This
Lordship,
is your daughter?
Lordship will examine. Then page 31, dear Lordship.
Yes.
Deposit, PW 10 deposit Rava. I know the informant and the accused person of this case. The incident had taken place on 9/11/2013. At that time, I was busy with regard to the activities of my organization, All Rava Students Union. I was informed about the incident by two members of my organization, ARSU, from village Hatidova, namely Sukleswar Rava and Harakanto Boro. Upon getting information, I, along with some of my colleagues of the organization, went to the place of occurrence, and we reached there at about 6:45 p.m. on the same day. At that time, I also informed the OC of police station, Hitoy Kolita, about the incident. So he was the guy who actually first
Yes.
informed the police. Upon going to the place of occurrence in village Hatidova, I saw the dead body of the deceased. I saw the dead body of the deceased inside the house of the accused. After coming to the police, of the police, they conducted formalities and I also saw the dead body. Upon seeing the dead body, I noticed injuries on the left side of the ear, cheek, and the neck. I noticed serious injuries on the neck. I saw one dove lying near the dead body of the deceased. I have not seen the incident of assaulting, killing of the accused, deceased. Prior to the occurrence, I have not visited the house of the accused and the deceased. I cannot say as to whether the dove which I saw lying near the dead body belongs to the house of the accused, but since it was found near the dead body, therefore, I thought that it belongs to the house. The police did not examine me with regard to the incident. So he also didn't ask the minor child about the incident. In page 33, Lordship will find PW 11, who was the OC, who got the first initial information. My name is Hridoy Kalita. On 9/11/2013, while I was at Polapuri police station as OC of the said police station, on that day, I received information over telephone from one Debojit Rava. He was that PW 10 called him. I recorded the information as GD entry. The extra copy of the said GD entry is Exhibit 9. Exhibit 9(1) is my signature. On the basis of this GD entry, I entrusted SI Sandrasekanta Kalita to investigate the case. In the meantime, on the next day, a formal FIR was received and a case was registered. Exhibit 1 is Azaha, Exhibit 1(2) is my signature, Exhibit 8 is the printed form of the FIR, Exhibit 8(1) is my signature. There was no cross-examination. Now, Lordship 313 statement. Page 34.
Yes.
So the first question was, Lordship, that a PW1 Bikram Pasari stated that on that one day his granddaughter Purnima came to his house weeping, and she told him that her mother Lotarava was beaten by you. Then he went to the place of occurrence and found his daughter Lotarava lying inside the house with injuries, and a dove was lying near the dead body of his daughter. But he did not find you in your house. What is your reply? So his basic plea is that, Lordship, I was in my own village.
In your
In my own village. So
village,
his own village is actually Soigao.
Levi,
He's saying that he was
Levi.
kind of Lordship.
If he's really a Levi, then it
He says
will
that-
heavily works against you.
and Lordship, but
If you are
what is there?
taking the plea of a Levi, because
what is
none of
there?
the suggestions,
Nothing is.
nothing,
I understand,
then-
Lordship, I understand that. But he's saying that like. he
then
has
it will work heavily against you. If you are taking the plea
Then-
of a Levi.
Then what I'm saying is that like
If
this is. his
own village
statement-
means Soyao,
Yes, his statement is
Then-
under 313, he's saying that he was in
because
my,
inside your own house,
I was in my own village.
be careful. Inside your own house.
Now, Lordship, what
Body was inside your own house.
body was in fact inside my,
So now you are taking the
no,
plea of
body was
Levi.
inside my own house.
You
But he,
you
but
don't owe any explanation
yeah, I don't know.
in some situation.
No,
some
I don't need any.
Some situations.
Yes,
But if you give an explanation,
then I need to understand that, Lordship. But what he's saying, I'm saying his statement of.
no,
statement
you are
what he's
at the
saying.
same time making submission here that
No,
I
no,
was at my
No,
own
Lordship,
village.
apparently.
His own village, he has the house there.
No, Lordship, Lordship, what he is saying, I am in my own village. I do not know about the incident. That is his answer.
So I have not
Then-
done anything as I was not in the house.
Then
You come to the answer, page 36.
I have
Question
done
number
anything.
9.
I was not in the house.
That is his plea. So Levi, 13 also.
Lordship may see page 37.
So it is a plea of
Yes.
alibi.
He's saying, he's saying that.
How alibi is to be proved?
I mean, there was no explanation to that. But
Uh,
the last question, do you have anything to say, anything more to say? I haven't done
First and
anything.
foremost is that for a plea of alibi, the most essential requisite, this has to be set up at the earliest point of time. If not, during the cross-examination of witnesses, then thereafter 313. Then by continuation of cross-examination and suggestion, you can reach 313. Thereafter, that is not sufficient, you have to reduce defense evidence.
I understand, but like, I cannot improve.
Those,
That is the
so,
statement, Lordship.
so this is,
But anyways, Lordship, I mean, these are the measure, I mean, depositions, I mean, that I have read out.
so
Certain-
otherwise, the child is consistent.
But that's what, Lordship, I would like to.
1 minute. The child is consistent.
Very clear.
The fact of her going to her grandmother's grandfather's house, which is at a distance of 100 meters.
Correct.
And that is corroborated by the informant. Informant. Her grandmother or father and the father of the deceased. So far that part. For a 4-year child, mother, father, grandfather, grandmother, uncle, they are the known person.
Absolutely.
If she was running 100 meters, some villagers are also seen. She was running, crying. Even Mr. Kaushik is known to face-wise. She will not say much. She will directly run to the
That's
grandfather's house. If it is 100 meters.
absolutely no problem in
So
that.
far. So that conduct for a 4-year child may not be abnormal.
That perfectly fine, Lordship, but only thing is that like one of the witnesses stated that he has seen the child talking about the incident in front of the house of the accused. That was a specific statement that has been made. That he had seen the daughter,
See
that
some-
minor child.
This indicates some glaring thing.
I mean, but this is one thing which I can point out from here.
Huh?
Say that we had a sort of capitulance, telling the informant in front of his house, telling the informant.
Let us see which part.
PW6.
Let us see which part you are indicating, Mr. Kulta. PW?
1 second. PW 6, Lordship.
Hmm.
What my learned friend is saying,
No, let us see.
I mean, anyways, Lordship, page 23.
Yes, which part?
The second line, Lordship, third line, just a minute, just let me read out. On the day of the incident, while I was going on my way in front of the house of the accused, in front of the house of the accused, means the place of
my.
occurrence. I saw Purnima, the minor daughter of the accused, crying and telling the informant that her father had cut her mother. What he was saying that like in front of the house of the accused, I saw Purnima, the minor daughter of the accused, crying and telling the informant that her father had cut her mother. So there is no, I mean, like making any interpretation in this. Very clear language. It's a very clear language that in front of the house. of
Is
the-
any of these witnesses are inimical to you? I think there is nothing indicated.
Correct, Lordship, correct. I can't deny that.
All are co-villagers.
But nothing on record as such, as far as like inimical or any kind of infights between them, nothing is there.
Only glitch was that the statement of the child was not recorded
Child was not recorded. None of
under
the,
161.
correct, Lordship, and none of
Right.
the, and
Thereafter, that IO had mentioned, and child also said that police did not record my statement. Then thereafter, during the course of the trial, Learned PP moved an application.
child was calling.
Because from the very initiation, the presence of the child cannot be denied. And it was quite natural. 4-year child inside her house when her parents are there. The GD entry was by a student organization president. He on his way, telephone. Before reaching the place of offense. There the police came. The statements of 161 statements otherwise from the case diary, they acknowledge the presence of the child and statement is recorded, child.
From the information the police gathered
Cool.
from the other people.
No, the other witnesses at the PO, that man says, no, IO, that I immediately after the GBD entry went there, recorded statements.
Correct.
And some of those statements bear testimony to the fact that the child was present and she told.
Correct. Which is, he got the
So
information from the
it
other
is
people.
not that it was child was implanted there. I am just indicating to that, yes, one glitch is that maybe the statement of the 4-year child ought to
Was-
have been recorded.
Was not recorded.
That is one.
Correct.
But at a separate stage, during the course of the trial, her name is emerging. PP moved an application. Court defense did not have any objection. Recorded it is in the order. And for the interest of justice, for the purpose of reaching the truth, court allowed it. Court had the power under 311. And this can be moved by any of the party or so motu. If witness is called at the instance of one party, the other party would have the right to prosecute.
Prosecute.
So this has been done. And the most important weapon is cross-examination.
Correct, Lordship. This is-
So this is a glitch. Yes, whether it is fatal. That is the only issue. Otherwise, so far, her intellectual capacity, the face-to-face, the session judge, a trained judicial mind has noted. We don't have to say anything.
No, that's,
We cannot-
that is where, Lordship, I mean, I'll have to,
So,
I'll have to place some.
so.
Yeah, I'll show it, Lordship. I'm coming to that, Lordship. I'll have to show that
We have
whether,
done with the testimonial.
exactly in a similar situation,
Sure.
exactly similar kind of 3 questions, Supreme Court has said, no,
Okay.
this is not the measuring
Okay, then.
scale. You cannot
Let
measure
us-
it like that.
Let us see that.
I'll just place it. Lordship. So otherwise, Lordship, in the factual part, Lordship, Lordship is clear.
None,
I mean, otherwise, there is no dispute on that.
none.
So this is Lordship 2023 SSC Online Supreme Court 777. A very recent judgment, Lordship, by Justice Oak. 2023 SSC Online.
Let us see the facts then. Exactly same.
I mean, exactly similar questions.
No, exactly the facts also.
The facts, Lordship, may be.
Let us see, let us.
Yes, yes. So I'll take your Lordship with the factual part. May I
para-
read out?
Para 2.
Para 2, Lordship. I'll just read out. First information report was registered on the basis of a statement of PW1 Ajay, who was 11 years old at the relevant time. He is the youngest of the 3 sons of the deceased Bhanmati and Satpal. According to the prosecution's case, on 30th December 2002, Ajay and his mother, deceased, were sleeping in their house by locking their house from inside. Ajay's elder brother was staying in Ghaziabad for education, and his second brother had gone to stay with his maternal uncle. Ajay's father Satpal was working as a Mahant of a temple, and he was residing near the temple. He was not residing with the deceased. According to the prosecution's case, at about 1 a.m., PW1 Ajay heard the noise of his mother. When he woke up, he saw the accused 1 and 2 were grappling with his mother. The accused number 1, Vicky, by knife inflicted 6-7 blows on the stomach and chest of the deceased. At that time, appellant accused number 2 was holding the hands of his mother. When Ajay tried to rescue his mother, accused number 1 inflicted injuries on him with the same knife. Thereafter, both the accused fled away. They had entered the house through a window, and they went back through the same window. According to Ajay, he was hiding in the house due to fear. At about 5 a.m., when once Surinder, milkman, who is described as Golu by PW6, came to the house, Ajay came out and disclosed to the said milkman that the accused had murdered his mother with a knife. The said milkman reported the incident to Ajay's uncle Rajinder Singh, who came to the site. Thereafter, Ajay's father Satpal also came. Injured Ajay was taken to the hospital where his statement was recorded. Based on his statement, first information record was registered. So this is the factual part, Lordship. In his complaint, Ajay had stated on earlier day, the accused had come to his house and untied the buffalo. When the deceased complained, both tried to assault the deceased. Ajay also stated that 6 to 7 months prior to the incident, both accused had entered the field of his family and they cut dowel of their field. As the appellant's father tendered apology to Satpal, complaint was not filed. Apart from PW1 Ajay, the prosecution examined PW6 Rajinder, Ajay's uncle, PW10 Dr. Varsa, who had examined Ajay. The prosecution also examined PW12 and Dr. Arun Garg, who conducted the postmortem and dead body of the deceased. But this is the factual part mainly also.
Submission also, para 5.
Yes, submission is that the learned counsel appearing for the appellant had taken us through the evidence of the material prosecution witnesses. He submitted that evidence of Ajay will have to be tested very carefully. As he is a minor witness, he pointed out that there is absolutely no corroboration of the testimony of the minor witness, which is full of material contradictions and improvements. He submitted that evidence of PW1 Ajay is not reliable. He pointed out that according to the prosecution's case, Ajay did not disclose the incident till early morning to anyone. He disclosed it for the first time to the milkman Golu alias Surinder, who came to his house at around 5 a.m. In fact, PW6 also claims that he heard the said milkman saying that the deceased has been murdered. He submitted that the prosecution has not examined the milkman, which is fatal to the prosecution case. He has submitted that the presence of Ajay at the time of the incident is extremely doubtful. He submitted that there was complete darkness in the house at the relevant time, and therefore it was not possible for the witness Ajay to see the accused. He urged that there is every possibility that the witness Ajay was tutored. In any event, he submitted that a very limited role has been described to the appellant of holding hands the deceased while accused number 1 assaulted her with a knife. Learned counsel appearing for the state while supporting the impugned judgment submitted that there is no rule that for maintaining a conviction on the sole testimony of a minor witness corroboration is necessary. He submitted that alleged contradictions and improvements in the testimony of the minor witness Ajay are totally insignificant, which do not make his evidence unreliable. He would therefore submit that no interference is called for with the view taken by both courts. Now, our findings from 7 onwards. We have carefully considered the submissions. The fate of the case depends on the testimony of the minor witness Ajay, PW1, under Section 118 of the Evidence Act 1872, Insert Evidence Act. A child witness is competent to depose unless a court considers that he is prevented from understanding the questions put to him or from giving rational answers by reason of his tender age. As regards the administration of oath to a child witness, Section 4 of Oaths Act 1969 is relevant. Section 4 reads thus. Section 4, oath or affirmations to be made by witnesses, interpreters and jurors. Oaths or affirmations shall be made by the following persons, namely all witnesses, that is to say, all persons who may lawfully be examined or give or be required to give evidence by or before any court or person having any law or consent of parties authority to examine such persons or to receive evidence. Interpreters of questions to put to and evidence given by witnesses and jurors, provided that where witness is a child under 12 years of age, the court or person having authority to examine such witness is of opinion that though the witness understands the duty of speaking the truth, he does not understand the nature of an oath or affirmation. The foregoing provisions of this section and the provisions of Section 5 shall not apply to such witness, but in any such case, the absence of an oath or affirmation shall not render inadmissible any evidence given by such witness or nor affect the obligation of the witness to state the truth. Under proviso to subsection 1 of Section 4, it is laid down that in case of a child witness under 12 years of age, unless satisfaction as required by the said proviso is recorded, an oath cannot be administered to the child witness. In this case, the deposition of PW1, it is mentioned that his age was 12 years at the time of recording evidence. Therefore, the proviso to Section 4 of the Oaths Act will not apply in this case. However, in view of the requirement of Section 118 of the Evidence Act, the learned trial judge was under a duty to record his opinion that the child is able to understand questions put to him and he is able to give rational answers to the questions put to him. This is very important, Lordship. He has to give his opinion. The trial judge must also record his opinion that the child witness understands the duty of speaking the truth and the state and state why he is of the opinion that child understands the duty of speaking the truth. This is not there in the deposition part, or that nothing has come on record that this has been given by the trial judge. It is well settled principle that corroboration of the testimony of a child witness is not a rule, but a measure of caution and prudence. A child witness of tender age is easily susceptible to tutoring. However, that by itself is no ground to reject the evidence of a child witness. The court must make careful scrutiny of the evidence of a child witness. The court must apply its mind to the question whether there is a possibility of the child witness being tutored. In this case, Lordship, this child was staying with the grandparents.
I have read.
Lordship, you have read.
His nevertheless,
Lordship, nevertheless,
sketchy,
yes.
then they could examine the testimony of the child witness.
Correct.
And he has been disbelieved because of his improved version in the cross-examination.
No, now Lordship may come to page that paragraph 11.
I have read.
Yes, paragraph 11, Lordship, only 3 questions have been the similar kind of questions. That's
11, first line.
Yes, in the facts.
12,
of the
12,
case.
12.
The-
You read 12.
No,
We are of the view.
no, first Lordship might kindly come to
Yes, I
paragraph
read.
11.
I have read. all
Let
three.
me read it again, Lordship. The preliminary examination was very sketchy, only 3 questions. Preliminary examination of the minor is very sketchy.
Then you read 12.
I'll come to that, Lordship.
I
So
have-
sketchy, only 3 questions were put to the minor on the
Ah.
basis of which the learned session just came to the conclusion.
So what is this then?
So
Pa-
3 questions are this.
12, 12.
Now, I'm coming to 12.
Okay.
Now, we are of the view that learned session judge has not done his duty. Nevertheless, we have carefully scrutinized the evidence of minor witness Ajay. In the examination, she stated that on so and so, the accused, so now the statement comes. Now, Lordship may come to kindly come to the conclusion part, paragraph 17. Apart from non-examination of the milkman, PW 11, Meher Singh, the investigation officer did not make investigation by recording the statement of elder brothers of Ajoy for verifying whether they were away from the house on the date of incident. After closely scrutinizing the evidence of PW1 Ajoy and considering that we have already observed the possibility of the witness being tutored cannot be ruled out. There is no support or corroboration of the testimony of PW1 Ajay apart from the other deficiency in the prosecution case as pointed out above. The facts of the case, it will not be safe to base conviction on the testimony of Ajay, which does not inspire confidence. So in my humble submission, the three questions which were put by the learned trial court, those are also very sketchy, very general in nature, very general in nature. Which school you go, that anybody can answer. Who are we you are staying with, that anybody can answer. That this kind of questions have been put and questions were not sufficient to understand the intellect of the child. And Lordship has seen it that he hasn't given his reason why he took that why he has given the value to the answers of the child. He should give a reason why that this is what the Supreme Court has said in this case. That reason has to be given properly. Lordship has seen that seen this. Only thing is written after aforesaid preliminary questioning, I am satisfied the child witness can be examined. So he hasn't actually at least little bit of elaboration, little bit of portion should have been
Where it is
adopted.
mentioned
Page
that
29.
report is to be submitted.
Lordship,
Some regions are to be
Yes, Lordship.
recorded.
that is there at page
Where is that?
in paragraph 8, Lordship.
Paragraph 8.
Paragraph 8, last
It
part.
is labeled.
However, in view of,
What is the report is? Opinion.
yes, opinion. Record his opinion. However, may I read out, Lordship? However, in view of the requirement of section 118 of the Evidence Act, the learned judge was under a duty to record his opinion. The child is able to understand the questions put to him and he is able to give rational answers to the questions put to him. The trial judge also record his opinion. The child witness understands the duty of speaking the truth and state why he is of the opinion that child understands the duty of speaking the truth. So this means why this is furthermore given stress that why he is of the opinion that the child understands the duty of speaking.
Okay.
So in this, case, Lordship has already, I have already pointed out, only these three questions, preliminary questions have been put up to the child. And these are very basic questions, Lordship. At least some questions would have been put, which would have shown the intellect of the child, but nothing has been done. And only thing is that said after aforesaid preliminary questioning, I am satisfied the child witness can be examined. He hasn't elaborated why he is satisfied, how he is satisfied. His opinion is not there. So Lordship, this And in this case, Lordship, like the, I mean, like, in distinction to the other case, their statement was taken probably. That's why improvement and all these things have come. But here, no statement has been recorded.
Is it fatal?
It may not be fatal, but it creates a lot of doubt with the veracity of the statement that the child has made. The child, after the death, the child was staying with the grandparents. We cannot rule out that the child has been tutored. And there is no other witness, so only one witness, that's it, that only the child. So, I mean, the court, in my humble submission, the learned court has to be very cautious about convicting somebody on the basis of a basis of statements of and like evidence of a child.
Was there anybody else in the family?
There was nobody.
Hmm?
But whether this circumstantial
No.
evidence or whatever,
Whether anything has come that there is anybody else in the family?
no. From my recording.
Yes, the prosecution submitted the application to the learned station judge. And to call the child who appears to be a material witness from the evidence and records of the prosecution case, and whom the IO did not examine. And the court should invoke the power under 311 CRPC. So, recent judgment in 311, court has elaborately explained what is 311. Okay, we'll taste that. Anything?
Another thing is that only one more thing, Lordship, as far as the motive is concerned, Lordship can see, the child has very specifically stated that there was no quarrel before the incident. So from the records, I could not see, Lordship, any motive is there. So in case of lack of motive, and in the case of basically here, though there is a child witness who is supposed to be the eyewitness. So in this case also, Lordship, the motive part is lacking. So and like as I have submitted here, Lordship, whether Lordship has to examine whether this child on the basis of the evidence of the child witness only, who is only 7 years old, while her evidence was taken, And while she was 4 years old when that supposedly the incident happened, whether that can be really relied on and then that can be taken into account in full strength and to convict somebody under
Yes.
302.
Judgments are galore when this kind of incident, hacking of mother by father, before a child of 4, 5, or 6 years had happened in front of his eyes, then it is deeply imprinted in the mind of the child and he can recall it at any point of time. Supreme Court judgment. What can I say? There are judgments.
I got it, but like I have placed.
So there are judgments. So no, I'm saying. So this way, that way goes. Every case has its own unique feature.
I understand facts are
So
different.
every case has its
Yes.
own feature. Every case has to be decided on the basis of its own facts.
Correct.
So
I- see, I-
propositions are
no,
there.
I have-
principles.
what Lordship has, what has come out from
No,
the
that
Lordship's
is what-
mouth, that is true, Lordship, that
See,
a child usually,
The-
the child usually understands that.
Something,
It goes to the child's mind, yes.
something which is very dastardly or something like which is very shocking, it creates
It goes, it is,
deeply
it has a,
imprinted in his mind and he can recall it exactly
what had happened.
after
with the-
some time,
That is correct, Lordship,
after a
but,
few years also.
but at the same time, Lordship,
Now we have to see
at the
if
same,
tutored or
at
not,
the same time, Lordship, my humble submission is Lordship will examine the aspect of tutoring
but he failed to demolish it.
and examine the, examine,
I have seen.
yes, examine the.
You have engaged experienced counsel. It is not a legal aid counsel. I have also seen that. You have engaged senior counsel during your trial, but you fail to demolish the child by cross-examination. I
But-
thought that
but-
that is also a factor. Free legal aid, all this, nobody is.
No, I think later on he didn't appear or something like that. Also. Somewhere it was written that
Application-
later on, yeah, he wanted to engage somebody himself, but later on, I think,
Bail petition, he has granted allowed bail
yeah, the petition was there, but initially later on probably,
later on.
I was- the amicus was used by the, Lordship, that page
My,
eight,
Chief
Lordship,
Sister, he
Lordship,
has the experience, many experience, 2 decades, how it is to be done.
mhm,
More than 2 decades experience, how a child witness is to be examined.
correct,
Mr. Kolita or myself does not
yes, yes.
have that experience.
Correct. Yeah.
So it is after,
We don't just immediately meet them in the courtroom.
Correct.
Morning hours, at least 1 hour, we talk to them. We interact with them.
Then
After that, we
correct, Lordship. But thing is that, Lordship, in this case, Lordship, particular case, that aspect hasn't come at all. Only thing is that 3 questions have been put and satisfaction was recorded. So, I mean, in Supreme Court was very clear in saying that like that aspect has to be elaborated a little bit, at least from the general reading of the Supreme Court case and a couple of lines the Supreme
it
Court has
says
stated.
sketchy. Thereafter, Supreme Court refrained from making further inroads into it.
The Supreme Court has, Lordship, if I'm not.
So Supreme Court also understands.
If I'm not wrong, Lordship, Supreme Court has very specifically stated why he is of the opinion that child understands the duty of speaking the truth. All these things has to come.
Supreme Court has not discarded it.
Yes, what Supreme Court has in clear language stated that opinion has to come in a proper manner, the manner it was stated in the Supreme Court's case. Language is very
Let me
clear.
see, I don't have an option. Use forwarding. Order sheet would put in order sheet. Order sheet would, when the child was examined, on which date?
Child was examined on 26/8/2016. If there is something on the record, Lordship may can examine. I could not examine. My apologies, Lordship.
Is that? Nothing has been recorded after putting some preliminary questions. Itu pun mobil. কিমান judge? কেইজন judge? Yes, so to say, Supreme Court says there is no principle of law that it is inconceivable that a child of tender age would not be able to recapitulate the facts in his memory. A child is always receptive to abnormal events which take place in his life and would never forget those events for the rest of his life. A child may be able to recapitulate carefully and exactly when asked about the same in the future. In case the child explains the relevant events of the crime without improvements or embellishments, and the same inspire confidence of the court, his deposition does not require any corroboration whatsoever. The child at a tender age is incapable of having any malice or ill will against any person. So therefore, there must be something on record to satisfy the court that something had gone wrong between the date of incident and recording of evidence of the child witness due to which the witness wanted to implicate the accused falsely in a case of serious nature. Now, what goes on is only effect could be the tutoring
You're correct,
in
Lordship.
between. Now, another Supreme Court judgment says the correctness of the opinion formed by the preliminary examination by the trial court as to why it is satisfied that the child witness was capable of giving evidence may be gone into by the appellate court. One, by either scrutinizing the preliminary examination conducted by the trial, which you have harped on, or from the testimony of the child witness. Second, or third, the demeanor of the child during the deposition and cross-examination as recorded by the trial court. Three options
So this
for the appellate court.
as far as far as demeanor is concerned, nothing has been recorded there.
Ah.
Nothing has been there.
So we are left with two options.
Correct.
One, which you have heard.
Correct.
The other one is testimony of the child witness.
Correct.
And regarding memory
Other-
recapitulation, okay.
other
But
factual
the
stuff.
tutoring part, yes. we
Yeah,
can look
other,
into.
other factual part. So
We can look into.
So in my case, Lordship, first thing is that like after the incident, that this child has been staying with the grandparents. That is one aspect Lordship has to take into account.
Yes.
Secondly, the child has specifically stated that there was no quarrel, nothing has happened. So motive part Lordship will look into. Thirdly, Lordship will look into this person, this accused is an outsider, basically. He is an outsider who came to stay in
They say it cannot
he,
be
he,
said.
he he is an outsider who came to stay there in the village. And
Cannot
all,
be said.
the Lordship, all the witnesses,
Too far inference.
all the witnesses are from the same village nearby, same village
Did they say?
of that, of the victim.
Did they say
the
they
victim.
fear animosity?
There is nothing on
This is
record.
too
Lordship. There is
far-fetched.
nothing on record. I'm just pointing out few aspects Lordship may kindly look into, because he is an outsider.
This is
and like all
not
these
to be
people have
looked
come
into.
and like
That is
deposed.
irrelevant.
They have deposed. And another thing is that there is, I mean, like little bit of whatever, that there is some contradiction as far as the place where the first information has been received. So that is one
First
thing.
information.
Yes, first information by the girl child to the grandparents. So that place, Lordship, there is a contradiction between two witnesses, because that what I'm saying is that whether this will create some kind of doubt, because I do not want any innocent person to be convicted under treason.
We also do.
So that is what my Lordship. That's perfectly Lordship. Lordships will also not want. That's why I'm just pointing out. This is some certain small things. Lordship will look into it, and in my opinion, Lordship, this
Yes, Mr. Kus.
this child witness, Lordship, that has to be looked into by a Lordship.
Lordship has heard my learned manner. Mainly his contents of which that one of those questions which were put to the child witness for examination are not proper. So my
Some region is to be recorded by the
lord,
trial court. That is what he has said.
yes, but that judgment, my learned man has pointed out on true, but whatever your Lordship has said, and that we know that paragraph, in spite of that, the Supreme Court has done the witnesses. In considering the other factors in the case, Supreme Court allowed the appeal. That's a different factor because it will depend on head to head. And my lord, in that judgment, I have just like made one opinion. My lord, the kindly privilege page, the paragraph 15 of that.
We'll halt here today, Thursday. Thursday we can put it.
And my lord, regarding
Bas, right away with the- Some other engagement is there, Mr. Kolka, on
Yes,
Thursday.
Thursday, Lordship.
We have heard your part.
Yes, Lordship.
We'll hear Mr. Kosik.
Yes, Lordship. I have some other.
You
reasons.
keep somebody here.
Okay.
regarding examination of the vulnerable witnesses, there is, I think there is one notification of our equipment. I will place them.
Please. And Mr. Ecolita and Amicus Creek for the appellant. Raise the case again. Raise the case on Thursday. For submission. From the additional purpose. For the response state. Yes.
11.
Much obliged, Your Lordship.
Yes,
Can it be fixed on 10th for hearing? If not 10th,
two
then
thousand twenty-two.
not 10th, then 19th, maybe. Possible.
Hmm?
19th of June.
Don't fix that, we don't also fix. See, after that, some date, 15 Bishop. Okay, and request to Mr. D.K. was Learning Council for the appellant, release the case on. 15 Bishop.
Okay.